appeal in the matter of Cérélia Group Holding SAS and A&R and Competition and Market Authority.
Yes.
Morning, my lords. Just to the who's appearing. I'm appearing with Ms. Berridge for Cérélia, who are the appellants, and Mr. Palmer KC and Mr. Bailey for the CMA. Can I start with confidentiality, which I'm bound to get wrong, and I apologise in advance, but I'll do my best. But you need to know about the confidentiality regime as well. And there are a large number of confidentiality markings in this case, and it's generally indicated by shading or a heading at the top of the document. So sometimes a whole document is confidential, it's just the heading that tells you. There is a nuance, there's a very delicate shade of lilac or lavender, I'm not sure which, but you'll know it when you see it. Apparently we are allowed to say that out loud, as long as it doesn't reveal the name of the particular retailer it pertains to, which sounds fraught with danger to me, so I'm just not going to read or try and say out loud the lilac and the lavender. Anything shaded I'm going to try and just invite you to read. And the final difficulty for all of us is that any retailer's name is confidential. So even though it's not shaded, we've got to try not to say a retailer's name. So there's going to be lots of nudges and winks from me, I'm afraid, but hopefully it will work.
It's retailers, but not the alternative manufacturers.
Say again, sorry?
Not the alternative
It's
manufacturers.
just the retailers, my understanding is. I know what you mean. Sometimes
I mean, I must say I was rather surprised by the over-enthusiastic level of confidentiality, which seemed to me to go way beyond anything that was sensible. But I probably come to it from a commercial lawyer's angle rather than a competition lawyer's angle.
it's good.
You wouldn't need to be a rocket scientist to work out who the retailers were.
No, I understand. And equally, you're absolutely right, my lord. There are occasions, I think, when the alternative retailers' names are shaded and not. And clearly, when I'm making submissions, the chances of me obfuscating who I'm talking about are close to zero. But the regime is there, and I'm going to try and.
Okay. Well, let's see how we go. But I don't want the appeal to be, as it were, disrupted by excessive resort to confidentiality issues which aren't realistic.
Yeah.
Is the table which sets out retailers' share of supply by range, is that range as attached to a name confidential?
My understanding is the range is not confidential. That's the purpose of it. I.e., you have the specific figures.
So we can identify as a particular named retailer as having a range.
Absolutely.
But we can't refer to the exact figure.
That's my understanding.
Because in the tables, I think in 5.5 and 9.1, we've got both an exact figure and a range.
That's right. I was going to give the range out loud. I'm sorry. Mr. Palmer tells me there's a draft order that's never been made in relation to confidentiality. Do you want to take it?
Yes, the confidentiality order in existence applied in the tribunal. So there was an application to this court under cover of a letter dated the 13th of December, simply asking the court with a draft order to make an order extending the effect of the tribunal's order,
Right.
so that it still has force. We can supply copies.
Yeah.
Well, I don't think we need to take time.
No, it simply extends its effect. If the court is content in principle, we can perhaps resupply that for it to be formalised.
Okay. Let's see if we get on with the substance of it.
So I'm going to begin with, it's a sort of case of two halves, if you like. Grounds 1 and 2 are sort of classic public law challenges of irrationality, duty to consult, etc.
Yep.
And grounds 3, 4 and 5 are really questions of statutory construction. So I'm going to start with grounds 1 and 2. I know you'll have done your reading, so I'll take the overview very briefly. Can we start with the Enterprise Act Authorities Bundle, tab 1. Page 1. So just setting out the general scheme of the Act at this stage. Section 22, sub 1, is the CMA decides whether it must make a merger reference, and you'll see the conditions that apply to that. And a merger reference was made in this case, and we're really concerned with the phase 2 aspect, the consideration of the merger, the reference having been made. And if you turn to page 17, and if you could read please section 35 sub 1 and sub 2, and sub 2 goes over the, sorry, sub 1 and sub 2. So you'll see that under what's called phase 2, the CMA decides inter alia whether a relevant merger situation has resulted, and that's not in dispute in this case, and whether there may or may be expected to result a substantial lessening of competition, which is, the shorthand is SLC for that, within any market or markets of the United Kingdom for goods or services. And then if you can go to page 20. Section 38, again, if I invite you to read section 38. So the CMA shall publish a report on the phase 2 reference. And then if we can go to the basic findings in the final report in this case, that's core bundle tab 10.
Apparently we need the mainstream amber candles all the way around, and we need 2 minutes to reset it. I don't know why this, time and again I say, all these things to do with the technology need to be sorted out before the case starts, not when the case is up and running, whether it's live note or live streams or whatever. It's time and again this happens. It's just badly organised.
I'm very sorry.
It's not your fault.
I know, but I'm sorry because it disrupts my flow as well. So
It's not your personal fault. at all.
sorry for me as well.
We'll just have to rise for 2 minutes, but I'm not taking more than 2 minutes. I'm going to come back in 2 minutes' time. If it's not done, we'll just carry on.
All rise.